Okay. All right, let's go on the record on, and Tony, we're going to be on the record on cause number DC205348, Convergence Aviation, Inc. and Convergence Aviation Limited versus Onala Invitation, LLC. Counsel, make your appearances.
Good afternoon, Your Honor. My name is John Palter, and Anthony Godfrey represent the plaintiffs in connection with this case. Mr. Godfrey will be presenting the arguments.
It's Scott Hayes on behalf of defendant Onala Aviation, LLC.
Okay, so you guys have submitted an agreed order, final order granting petitioner's bill of review. So give me a little feedback or a little background to kind of what led to this order.
So, Your Honor, we originally filed this petition for bill of review as the third proceeding in front of Your Honor related to this claim. Originally, we tried to serve opposing counsel by contacting them directly and then also by granting them service. They declined to file an answer until immediately after we filed our motion for default judgment. So we've revoked that motion. And then this morning, in advance of the hearing, we received notice from Mr. Hayes that they would agree to our bill of review and proceed to a trial on the merits in the preceding lawsuit vacating that default judgment that was issued back in 2018.
So what was the original lawsuit about?
So the original lawsuit was filed in your court in 2015, and that lawsuit was related to a dispute concerning the title to a specific aircraft engine. On a motion for summary judgment, you entered a judgment in favor of the plaintiffs in this case, Convergence Aviation and Convergence Aviation Limited, determining that defendant Onala Aviation had no right or interest in the title to that specific engine. 13 days after you issued that final judgment, Mr. Hayes and defendant Onala Aviation filed a separate cause of action in the 44th District Court seeking damages for breach of contract due to failure to provide the title to that engine, and also seeking specific performance of delivery of the title of that engine, the very same engine that just 13 days prior to that filing, you had issued a final judgment explaining they had no right or title interest. We never received service for that second lawsuit, and rather than proceed, they received a final judgment on a motion for default judgment in that second lawsuit, which granted them title to the very same engine that they had previously been denied title to, as well as damages for the breach of contract.
Did I sign the default, or did Judge Goldstein or Judge Cortez file the default, to sign the default?
After the filing of the second lawsuit in the 44th, about a year or so after that filing, it was transferred to your court. So you did sign that final default judgment in the second lawsuit. We received notice of that default judgment about a year or so after it was filed. So it was well outside the window for a motion for new trial.
And you're saying in the original lawsuit, there was no service?
In the second lawsuit, there was no
I'm
service.
sorry, in the second lawsuit, there was no service?
Correct, Your Honor.
But we granted a default judgment or they requested a default judgment and granted a default judgment anyway?
Yes, Your Honor.
Okay, that's a little unusual, but all right.
The position of defendants Onala Aviation at the time was that they had effectuated service by serving the Secretary of State and having the Secretary of State forward that notice of the judgment to a Delaware address that was purported to function as service for Convergence. That same address was not accessible in the first lawsuit and continued to not be in the second lawsuit, and they never notified counsel.
So there was an attempt at service, but you guys have agreed that that wasn't through the Secretary of State, because generally serving the Secretary of State is sufficient to show service, but I'm guessing in this particular case it wasn't because y'all didn't include the right address. Is that the idea?
More or less, Your Honor, yes. We
Okay.
contend that they should have notified counsel, and also that we are not a foreign corporation subject to service on the Secretary of State. We are a domestic corporation registered with the Secretary of State since 1996.
Okay. All right, and so I can see how that would be grounds for a bill of review. So if I agree to this order, then, and the original lawsuit, I guess, or sorry, the second lawsuit, I guess, was already transferred from the 44th to the 68th. Is that right?
That's correct, Your Honor.
And the cause number that you're wanting us to use is out of the second.
As the
second
order is,
lawsuit?
correct, as the order is drafted, Your Honor. That's the one that made the most sense to us, since the first has been disposed of. The second is where the default judgment is being vacated.
And in that first lawsuit, it sounds like we've done quite a bit of discovery. Is that right?
That is correct, Your Honor.
So in the second lawsuit is just a mirror image of the first lawsuit. Is that correct?
That is our position, yes.
So there isn't the need for any more discovery. Is that correct?
We would not request any additional discovery. I don't know the degree to which O'Neill Aviation may request discovery, but I don't believe that we would need any. We will likely proceed directly to a motion for summary judgment.
Okay. Mr. Hayes?
Sure. Our position is the claims in the two suits are distinct. Yeah, I anticipate there's going to be a summary judgment where they're going to say res judicata.
Mr. Hayes, you got to speak up.
Sorry, Your Honor. The anticipation, our position is the claims in the two suits are different. I anticipate they're going to claim res judicata, et cetera, and we'll defend that, but I don't think there's a lot of discovery. I anticipate that will be the first motion in this case. But we'll have our arguments that these are separate and distinct claims that, again, were brought before the court in the previous case with a motion to amend. And at that point, that was not granted. And counsel for Convergence said, yeah, that's a separate, distinct claim. But I don't think there's probably a lot of discovery necessary at this point in time.
The reason I'm asking these questions is primarily just to figure out when we need to set this for trial. And it sounds like maybe 2 months.
Yes, Your Honor. We just need time to brief a motion for summary judgment and get that before Your Honor.
Judge, no, I'll take that back. There's not, in the 20 case, there's a trial setting, but I think in that time period, yes, we could proceed on our claim.
So this would this close the 20 case? Is that the idea? This order would close the 20 case?
That's correct, Your Honor. It would close
Yes.
the 20 case. It would
And
vacate.
reopen the 16 case?
Exactly.
Yes.
Okay. Wow, that's an unusual way to do that, but I guess that makes sense in this particular case. So 2 months enough time, Mr. Hayes?
And I might actually want a little bit more than that, because if I want to know what their defenses are if they get past their summary judgment. I understand where they're coming from on that, but we get beyond that, then there will be claims that where we're seeking money as to the agreement that there hasn't been discovery on that I recall. So I'm thinking it may be a 4 months.
4 months, okay. Okay, so we'll go ahead and set this in December trial. Thanks. I don't know what that was. Oops, okay. All right, so we'll set it for trial. Anything else we need to do today?
No, Your Honor.
Your Honor.
Okay, we'll go ahead and get that. And then, Rhonda, this is a little bit complicated because we're closing this 2020 case and we're reopening the 2016 case. And then we have to set the 2016 case for trial. So it's unusual. So all right, but I'll give you a call about that and I'll fax you the order. Okay, guys, anything else?
That's it, Your Honor. Thank you very much.
No problem.
Thank you,
We'll go ahead
Judge.
and get this taken care of.
Your Honor.
All right, I'll be right back, guys. Well, guys, that was kind of an interesting hearing. So have we talked about what a bill of review is yet? So bills of review are kind of interesting. They're complicated. So we'll talk briefly about them. I think one of the interns wrote, who wrote on the Keisha case. So you're kind of an expert. Why don't you explain what a bill of review is?
Judge, you're still on YouTube.
Oops. Okay. Sorry.